Same respondent. Same respondent.
That's okay. They have to take this in appeal to Supreme Court.
Some of the arguments that you're presenting have not been considered here. They're per inquiry.
Court officer. Court officer.
With that order.
Judgment copy. Page 3, para 2, Malak. The learned counsel for the petitioner urges that the appointment of private respondent with the status cabinet is without jurisdiction and unconstitutional. In support of his contention, he heavily banks upon Article 164 1A of the Constitution of India, which prescribes that the total number of ministers, including chief minister, in states shall not exceed 15% of the total number of members of the Legislative Assembly. The council submit that this ceiling limit is breached by appointment in question. The learned so-and-so appearing for so-and-so opposes the contention, my lords. Then can I request, my lords, page 5, para 4. The above text is as clear as Gangetic water. It is nobody's case. The private respondents have been appointed as ministers. If a private respondents were appointed as minister, there could have been a scope for invocation of subject provisions of the article. Merely because the cabinet status is conferred on a particular appointee, that per se does not make him a minister within the meaning of Article 164. These respondents are appointed as to assist the chief minister by ministers, and they are not functioning as ministers in the literal sense. Therefore, the provisions pressed into service by the learned counsel for the petitioner is not attracted. The status of cabinet rank is conferred on persons appointed to by post other than that of the ministers as well needs no research. Since the enactment of the constitution, several states, examples, Assam, Meghalaya, etc., persons are appointed with such status even when they are not ministers of the Council of Ministers. Such status is conferred on various reasons that fall within the exclusive domain of the executive, and therefore court cannot undertake their deeper examination in judicial review. The text of the impugned order shows that the conferment of this status is for the purpose of extending to the appointee the facility that avail to the ministers of cabinet rank. Despite vociferous submission, learned counsel for the petitioner is not in a position to show which rule of law which has been violated by virtue of impugned appointment. In the absence of breach, no relief can be granted. The Lordship may kindly turn to page 2, my lords. Respondent number 3, 5, and 6 are respondent 3 and 4 are respondent number 46 and 47. Respondent number 46 and 47. The same principle.
Same appointees.
Same respondents here, 4 and 5, 46, same nature of notification. 46 and 45, page 11 of their writ petition, my lords, page 11. 46, 47, here 4, 3 and 4. On the same lines, the argument is the same different orders.
Can I address minutes? Article 191 has not been dealt with here.
Which one?
In this particular judgment, because we have raised grounds of challenge under article. Please, this judgment that has been cited.
Which article not dealt with?
Article 191,
Like
which
one.
speaks of the prevention of disqualification with respect to office of profit. In my petition, I have raised.
So this will amount to office of profit.
Yes, we are actually saying it doesn't fall under exemption.
Then it is not a cabinet rank.
Milords, if I may say so, that's what happened. So if I may just make this submission.
Both may not go consistent.
Can I just answer this question? What has happened is, they have tried to peg these posts under the legislation which enjoys the benefit of Article 191. In addition to that, they've also given them the post of a cabinet minister or equal to the cabinet rank. So one is whether it passes muster on the annuals of Article 191. And second, having given them the same treatment as a cabinet minister, there's a second violation under Article 164 1A. That's been the argument in my petition. That is not the argument that's been raised here. Firstly, in this case, could my lords kindly come to the judgment? Please, could my lords come to paragraph number 16 of my writ petition on the grounds? My very first argument is violation of Article 191, Office of Profit, because some of the posts that have been specifically extended the benefit under the Prevention of Disqualification Act do not fall within that particular exemption. So allow me to show that. This is my first ground, violation of Article 191, Office of Profit, appointing members of the Legislative Assembly and members of the Legislative Councils as chairpersons of boards and corporations with cabinet rank benefits constitutes holding an office of profit. This makes them ineligible to serve as legislators as per Article 191 of the Constitution.
Where you are reading?
Please, minutes.
Reading where?
This is paragraph 16 of the writ petition, page number 17. This is my very first ground of challenge. So the point is, if they say this judgment covers my position, it does not in entirety, because there are multiple grounds in my petition.
Paragraph 16.
Paragraph 16 at page number 17, violation of Article 191, Office of Profit. The second ground is Article 164, non-compliance.
Law. Let us go slow.
Please.
Read 16, appointing members. What is this ground? Let us see.
Can I just answer the question? Good, my lords, take a look at the Prevention of Disqualification Act and Article 191. I'll explain the argument right away. Kindly take a look at Article 191 for a moment. Just give me Article 191. The provision says, does the bench have it? Article 191. Disqualifications for membership. A person shall be disqualified for being chosen as and for being a member of the Legislative Assembly or the Legislative Council of a state. Please see A. If he holds any office of profit under the government of India or the government of any state specified in the first schedule, other than an office declared by the legislature of the state by law, not to disqualify its holder. We are making the submission. So under the second provision, they have the Prevention of Disqualification Act for Karnataka. Therefore, we are saying some of the positions which have been notified for the purposes of exemption don't even attract those provisions, in the sense it is outside the scope of this exemption. So my very first ground is that it directly attracts 191A. I'll show that from the legislation as well as the notifications which have been impugned. And the second ground is, having elevated them to the status of a cabinet minister, the rank of a cabinet minister, it then triggers the application of 164(1)(a). So the very first ground is Article 191. Can I just show the Prevention of Disqualification Act for a moment for my lord's consumption? There are only 3 sections in that entire act. It's fairly clear. But my lords, kindly come to the Karnataka Legislature Prevention of Disqualification Act. Give me one copy. And then I'll show the impugned notifications to show on the face of it how they violate this. So, my lords, the provision would start, so the act starts at page number 3 of this compilation. It has the statement of objects and reasons in the first 2 pages. Then my lords could come to page number 3, which has this act. Does my lords have it? Please, minutes. Kindly see the relevant definitions: committee, compensatory allowance, and statutory body. Let me read out committee and statutory body before I come to section 3, because section 3 is the prohibitive provision. Kindly come to section 2A, committee. Committee means any committee, commission, council, board, or any other body of one or more persons, whether statutory or not, set up by the government of India or the government of any state. Then kindly come to the definition of statutory body, my lords, which is 2C. Statutory body means any corporation, board, company, society, or any other body of one or more persons, whether incorporated or not, established, registered, or formed by or under any central law or the law of any state for the time being in force, or exercising powers and functions under any such law. This is the meaning of a statutory body for this act. Kindly come to section 3. Removal of certain disqualifications. My Lord Justice Arun has it. Please, minutes. It is hereby declared that the following offices shall not disqualify and shall be deemed never to have disqualified the holders thereof for being chosen as or for being members of the Karnataka Legislative Assembly or the Karnataka Legislative Council. So only these offices will get the benefit, Millards, for the purposes of disqualification. The office of a deputy...
They are not the offices of profit.
Correct. For the purposes of Article 191, this is the exemption. The second part of Article 191A is being satisfied through this, which is why it says removal of certain disqualifications. The office of a deputy minister